I will go through. So a lot of people have asked me, hey, are you doing a contracts redline class? Are you, when is the contracts update class going to be released? And I'm not doing one. And the reason I'm not doing one is because I feel like doing a contracts redline class or calling it that and getting all these brokers to attend it is a little misleading because there really aren't many changes this year. I'm going to talk about what they are and what you need to know. But the reality is they only changed in substance really one form. And that form is actually going to be discussed in my pitfalls class. I go over it, but it's also going to be in the 2021 annual commission update course. But I'm going to just go through it real quick so you guys know, but if it's repeat when you take those classes, then well, so be it. But at least you know what's changed. You know why at least I'm not offering that class. So the first thing, the one that really changed, honey, did it show up?
Yes.
Okay, so the one that really changed is the post-closing occupancy agreement. And I'll tell you, it looks like a lot of red on here, as you can see. It's really not that much. A lot of this is clarity, fixing, like here you see terminated, went to null and void, just because of the language in the terminated in the contract, and we didn't want it to be misleading. Put a header on paragraph 1 about the parties and properties. So most of this is just clean up, clarification to make it read a little cleaner. The one things I do want to point out that did change is under 3 possession, it says seller may retain possession of the property from the date of closing through blank. So it used to be you put in the number of days that you were keeping it. So it was, it was for 10 days or one. Now it's just through blank. There's a deadline on it. So it reads a little cleaner. Still can't be used for over 60 days. That has not changed. But it's just to try and make it so people know what their end date is instead of trying to count days from closing, because that was a little weird. The other big changes.
Zooming in on that a little bit.
I'm sorry?
Can you try zooming a little bit?
Oh, sure. I'm sorry. I meant to do that. How's that?
There we go. Hopefully that's a little better for everybody.
Okay, so possession, this is the one I'm talking about. They changed that. The other thing that really was updated was damage to property is from the date of closing instead of before, because at that point the buyer has accepted the property on the day of closing and the condition it's in at that point. So any damage is after closing. So that was clarified. The insurance was updated. One of the issues that we were having with insurance was the fact that the post-closing occupancy required the seller to get liability insurance, which it turns out that's not even really possible for them. So having that in this post-closing occupancy agreement didn't make sense. You'll notice it still has a seller's renter policy, and we tried to clarify as to what exactly the seller needs to get if the box is checked. Because what happens at closing is that the buyer becomes the landlord, the seller becomes the tenant. So the tenant slash seller needs to make sure that they've got coverage for their personal property. Likewise, 14 was updated to try and make it clear for the buyer that they need to make sure they have a landlord policy. One of the concerns or issues that we've seen is buyer closes on the property, seller stays in for 60 days. If the place burns down in between that time and the buyer did not get a landlord policy, the buyer may not have coverage because they weren't living in the property. So again, insurance in the post-closing occupancy agreement has always been the big issue that we want to address when we're talking about when we're dealing with post-closing occupancy agreement. That's why we have it in there. But the other big change, and this and I love, some of you might freak out, but I don't care, is security deposit. So you can see here under security deposit, we used to have this concept that seller agrees the security deposit amount of blank, and it said will be held by buyer or check the box, throw something in there. Okay, and what's been happening is they've been throwing in by a listing broker or buyer broker or title company. That's the one I see all the time, is that, oh, we want the title company to hold the security deposit. Well, that creates all kinds of problems. The reason it creates these problems is because the buyer is a landlord. The buyer has obligations when they have a security deposit about sending out a letter telling people, okay, here's the damage and here's the disposition of your security deposit. But if a title company, for instance, is holding it and the buyer says, okay, they damaged the property. I need 50% of the security deposit, title company, or I need the whole thing so I can distribute 50% to the seller, or I can distribute whatever per the statute. And the seller says, oh no, I want all of it. Now the title company's in this position of freezing the money, but yet they're not the ones that are responsible for disposing of the money per the statute. So this was updated to make it actually line up with landlord tenant law. And so what you see, it says seller agrees that a security deposit in the amount of blank payable to buyer will be paid at closing and held by the buyer, period. There's no options anymore. There's no, let's give it to somebody else that gets put in this terrible position of trying to figure out what to do with this security deposit. It goes to the buyer. And for those of you that are like, well, wait a minute, what about my seller? We'll get to that in a minute. But it does make sense because it lines up with landlord tenant law. Landlords are supposed to get security deposits. That's the way it's supposed to work. They're not supposed to be held by third parties. They don't envision being held by third parties. So that's what this says. For those of you that have sellers that are concerned about the security deposit being held by the buyer, which I get, well, they have a couple options. Okay, the easiest one is don't stay in the property past closing. I mean, that's what the lawyers would prefer anyways, is that when you have a closing, the seller moves out, the buyer moves in, and we're done. Let's not have this game of, oh, we're going to live in there for 60 days. That's ideal. The other thing is sellers should negotiate the security deposit for whatever amount they want. 0 is acceptable, but that's the way this should work because this document really is a lease. And because it's a lease, the buyer should be the one getting that money and holding it pursuant to the lease. So that's really the biggest changes that happened in the contracts. And I see some questions coming in, Jill. Do you?
Yep. So first one, security deposits are required to be put in an escrow account. Will this require buyer landlord to get an escrow account for 60 days?
Okay. So what you're talking about with required to be in an escrow account is if it's a buyer, if the buyer happens to be a broker. That's only for broker owned properties where they're the landlord. And yes, if the buyer is buying the property and happens to be a broker and is holding the security deposit of the seller, that should go into a trust account. But keep in mind, that's not for every single buyer. That's only for buyers that are licensed brokers. Regular buyers can put it in their own funds. That's allowed under the regular landlord tenant law.
Several insurance companies told my sellers that the insurance company would just keep their full policy active until they moved out, whenever that would be. Is that even possible if the sellers don't own the home anymore?
Hey, as long as they're getting something in writing and assurance from their insurance company, I'm good with it. The whole point of having this in the post-closing occupancy agreement is to make sure sellers are having that conversation with their insurance company. If the insurance company has something in writing to them that says, yeah, we'll cover you after you don't own the property, it would be really hard for them to deny a claim if something came up. But the point being, we don't want to be in a position where the broker gets blamed because the house burns down, the seller's property is lost, and they go to their insurance carrier and say, well, you don't own the property and you didn't have a renter's policy, so sorry, you're out of luck. That's the whole purpose of this, is to make sure that we're getting sellers and buyers, for that matter, talking to their carriers about what coverage they need to make sure that during that gap period of that post-closing occupancy agreement, that the losses are covered by the carrier.
On PO agreements, do you recommend 2 walkthroughs, one before closing, then another after the end of the PO term?
Well, so I mean, after the post-closing occupancy term, obviously this buyer is going to have possession of the property, so they can go over there anytime they want. They don't have to do a walkthrough. But yeah, I mean, you want to do a walkthrough at the time of contract or at the time of closing to make sure that the property, you know what the condition of the property is. And then anything that changes, and I would, maybe even talk about videotaping or doing something so that if the seller damages something on the way out, like maybe it's after closing, you go over there. But that way, if the seller damages something on the way out, you have some kind of proof of what was damaged. This is always a fight. That's why I still don't like post-closing occupancy agreements, but at least this helps cover brokers.
And we had a question from before, will we receive a copy of these changes, the version with red and green text?
They're on the website for Dora. I'm happy to, Jill can send you the link if you want to go to that, or I can provide, I have PDFs of them, obviously, because I'm on the forms committee. Jill, I'll just let you decide what you want to do. If you want to
I'll
just
send out links.
but yes.
It's easy to get.
What's that?
I'll send out links with my
Okay.
follow now, so it's just easy to access.
Okay, perfect.
Another question just came in. With the post-closing occupancy agreement, should the buyer get a copy of the key at closing?
So one of the things this says about access is that they can access the property in the event of emergency. I will tell you, I don't know of any landlords that are okay with a tenant having access to the property and the landlord not having access. So to me, it seems that the buyer should have access. I will tell you, I know this has been a bone of contention. The problem with these post-closing occupancy agreements is that the seller who has sold the property still has this belief that they own the property and have these rights as an owner, and they really don't. They're now a tenant. If you want to make that clear, maybe that's something that you put in the additional provisions in the post-closing occupancy agreement. I'm thinking now that maybe we should have added it in this, but where was that suggestion when I was working on the stupid form? But anyways, yeah, I think a buyer should have a key. I really do.
All right, I think that's it for now. So we can.
Okay, so that's the biggest form that changed. I'm going to show you guys. Did that come up, honey?
Yes. But Zoom.
Okay. So I'm going to show you a couple of the other forms that changed. These are minor changes, and frankly, for the majority of you, you won't even deal with these. Brokerage duties addendum to the property management agreement. This is a required form for property managers. So if you're doing property management and you have a property management agreement, you have to have this form attached to your property management agreement. That is required under Rule F.
Don't forget
The only thing that really changed is here in paragraph 3.3, they updated the default. And this was to match all the changes in the listing contracts last year. It used to be you had to check the box to be a TB by default. Now you do not check the box. And if you guys, a lot of you that have taken my classes, I'll sit there and pound on you with the listing contracts about do not check the box in 4.3. This is paragraph 4.3 equivalent for this document. So now it's all consistent that a broker by default will change to a transaction broker if they have a relationship with both parties, instead of it being that they were an agent automatically unless they check the box.
Hey, Damian.
Yes.
Can you zoom in again?
Oh, I'm sorry. Maybe. Okay. So here in 3.3, did that help?
Yes.
Okay. This is the one that just changed the default. Do we have any questions on that?
Hold on.
Because that's all I got on that form. It's really, really simple.
Let's see. We've got a few questions, but it was from the previous form.
Okay. You want to ask those before I go on to the next one?
Sure. Okay. So I see sellers or tenants not wanting to give keys at closing. Contract says seller will provide all keys.
Yeah, it does in the contract. I would probably add in the post-closing occupancy agreement too, to be clear, because it's a constant battle to get the keys. Like I said, sellers still think that they're owners, not tenants, and that makes it difficult.
Yeah. How would you word that verbiage in additional provisions?
I would just put in there that tenant shall have copies of all keys at the start of this post-closing occupancy agreement. I mean, it is covered in the contract. The problem with the contract is it's buried in one of those provisions and inclusions. And so the nice thing about having an additional provisions of the post-closing occupancy agreement is that it's language that everybody sees. If you're using CTM, it's in blue. So it makes it a lot easier to know that that was a term. So I would just put in there that seller will provide a copy of a key to the tenant upon, upon the start of this agreement or something, or beginning of this agreement or whatever. So that's what I would do with it.
And is this required with possession within 24 hours after closing?
Well, the lawyer in me says that anytime they're going to be there after closing, I would have this. Again, the purpose of this form is to protect the broker. I mean, it protects clients too. And obviously that's the intent. But from my perspective, as an attorney that only represents real estate brokers, it's to make sure that buyers and sellers know about the risks. Like I said, the insurance is the biggest thing. And even 24 hours can mean, it burns down within that 24 hours. It can still mean that there's no coverage. And having this form and having a buyer and seller sign saying what they're doing with the insurance protects the broker. So for me, anytime they're going to be past the day and time of closing, I would use it. I know that gets a little difficult at times, but that's just my thought on it.
Somebody commented, seller to give a copy of all keys to buyer at closing. As far
Yeah,
as
you
that.
could do that. I mean, because it does say I don't have the form up, but it does say that the term starts on the day on closing. So that would work.
And somebody asked to see the top of this form.
Top of this form. This form is the brokerage duties addendum to the property management agreement. Okay, that's the one. If you're doing property management, this must be attached to every single one of your property management agreements. And I'm just making sure you guys know that because there's some attorneys out there that don't understand this is a required form under Rule F.
Somebody commented, doesn't a buyer get insurance on the home at closing, assuming they purchased with a loan, of course, so insurance should be in place? Well,
yeah, except the problem is that when a buyer who's purchasing the property as their principal residence, their homeowner's insurance is for that as a homeowner. It's not as a landlord. And so if there's a 60-day post-closing occupancy agreement and they don't have some kind of understanding with the insurance company or some kind of endorsement with the insurance company saying that they have a landlord policy, I have seen them deny coverage based on the fact that the buyer was not living at the home at the time of the loss. So that's why this is all important.
Got some more questions coming in here. Is it not better for the broker to advise their client to change the locks?
I don't know which client we're talking about, so that's hard for me to answer. I mean, if the buyer could change, yeah, I would change the locks after the post-closing occupancy agreement's over. I don't know why you'd do it before, as long as you have a key and access. And I certainly, if you're representing the seller, I wouldn't tell them to change the locks because then you got problems about giving the buyer access.
Is this form for lease required on our personal rentals?
No, this is post-closing occupancy on transactions. This has nothing to do with your personal rentals. You need to use your own lease form for that.
How about if we are, let's see. Okay, this is the same question. If we're only managing our own rental units, use of this form.
Yeah.
Is day one of the 60-day post-closing occupancy the day of closing or the next day?
It's the next day is day one.
Lender has.
I think that's one full day. It starts on the day of closing. So that's a great question. I think that's part of the reason we changed it to having a term that you put a definitive date in there instead of days from closing. But one day from closing would be, if you closed at noon on Thursday, one day would be noon on Friday. I want to try and get through the rest of this stuff. I see. Can we come back to these maybe if we get through some of these?
Sure. Yeah, that sounds good.
I see questions on the property management addendum is only if you're doing property management. That is not for your own rentals. If you're not, your own rentals doesn't count for this. That's only when you're doing property management for a third party that you would need this brokerage duties addendum to property management agreement. Okay, this one, it was also changed. It's the same reason as the one for the property management agreement. This is when you have REO or maybe a commercial client or somebody that does not want to use the real estate commission approved listing contract. Excuse me.
Don't forget to Zoom.
Oh, yes, thank you. So if they are not using the real estate commission approved listing contract, then this form must be attached. And that goes for really anything as far as, you know, I've seen a lot of commercial brokers, they'll have their own their own listing contract. I've seen landlords have their own listing contract. I've seen banks have their own listing contracts. I've seen our relocation have their own listing contracts. Any of those listing contracts that brokers sign, this addendum needs to be attached. That's again under Rule F. And all that really changed in this one again is that default language. This is in 3.3 also, which says that by default, you become transaction broker if you have a relationship with both. And if you check the box, then you're an agent only. So that's all that changed in those two forms. It was to make them consistent with the listing contracts that we had. I'm going to keep going. I know we got all sorts of questions, but I do want to get to this Red's questions, and I know we're at 2:30 already. So next I want to talk about the biggest thing that the Real Estate Commission did was they created a suite of forms for manufactured homes, because I know all of you out there just love listing and selling manufactured homes. The problem has been that brokers have ended up in the middle of, and when I say manufactured homes, I want to make sure that we understand there's two types. Okay, there's manufactured homes in a park, or a mobile home park, as you call them. Those are manufactured homes that you guys sell. And then sometimes there's a manufactured home that sits on a lot, like a vacant land with a manufactured home on it where the deed has not been purged. So what the Division of Real Estate realized was that brokers have been involved in these transactions, but for some reason, brokers always use the contract to buy and sell real estate, which doesn't make sense, because when you're dealing with manufactured homes, you're not selling real estate. You're selling personal property. So the contract to buy and sell does not work for manufactured homes, which I know is going to come as a big shock to a lot of people that have been selling these, because they felt like they had to use that contract to buy and sell, but it's not the proper form. I will tell you, manufactured homes are difficult transactions. They're very different because you're selling personal property instead of real estate. So while some of the terms about inspection or even appraisal or even loan might be similar, a lot of none of the title stuff applies if they're in a park. It's mostly just, title companies do not like to close manufactured home transactions. In fact, they won't close manufactured transactions if there's no real estate involved. I have heard of some doing it in areas where there's more manufactured homes than in others, but for the most part, these are really dangerous transactions. And so one of the reasons I'm not doing a contracts update class is because I think the majority of brokers out there are not doing manufactured homes. They're just not. However, if you are doing manufactured homes, if that is something that you help people buy or help people sell, or you're supervising those transactions, you really need to take a class on manufactured homes that'll really dive into the ins and outs of these transactions. And that includes, there was a memo sent out by the Division of Real Estate from DOLA, which is Department of Local Affairs, which happens to include Department of Housing. And essentially, the Department of Housing is giving guidance as to what brokers can and can't do under the exemption in the statute. And these contract forms were drafted around that exemption. There's still a whole bunch of transactions regarding manufactured homes that brokers are not allowed to participate in unless they're registered as a dealer with the Division of Housing. So if you are going to go into this world of manufactured homes, you really, really, really need to take a class that's a line-by-line class going through this contract and understanding the ins and outs of it, because while we tried to make it similar to the contract to buy and sell, there are a lot of substantial differences. I'm just going to point out some because I see we got all sorts of questions coming in. I don't know if it's all on this or not, but you can see that it defines what the home is. You'll see there's nothing on title. Inclusions and exclusions look similar. It has some leased items. Dates and deadlines are different. They have UCC and title deadlines instead. The purchase price looks the same, but then there's some differences as we go through the contract as far as, how the loans work, what kind of loans you can get. So this is really, it's really a form that you need to understand if you're going to do these transactions. It is enough different to cause problems. So It is, on the other hand, though, shorter. So if you want to just focus on manufactured homes where you make a commission of about $500 a transaction, and you want it because you wanted a shorter form, there you go. Now you got a shorter form so you can do those transactions. So, but what they did was, I'll tell you, if you're listing manufactured homes, I'd use the regular listing contract. There is not a specific form for manufactured homes or listing a manufactured home. But if you are going to sell a manufactured home, you have to use one of two forms. This one is the contract, which you'll notice at the top, it says lot lease only. So this is for when you have a manufactured home in a lot, or that's on a lot in a park. This is the form you use. I'm not going to blow these up, honey, because they're not necessary. There's a counter proposal that goes with that contract form. And then there's an amend extend that goes with that contract form. So at least brokers that are working in this area or working on these kind of transactions have all the forms like you normally would under a contract to buy and sell. And you have the ability to modify the provisions as you need to throughout the course of the transaction. There is not an inspection objection. There is not an inspection resolution. There is not a title objection. It's not as robust as the contract to buy and sell, just because it was impossible to put all that together at once. And frankly, we wanted to see how it functioned. If you have objections, send them by email. It's fine. You don't have to have an objection form. If you have resolutions, do it by the amend extend. That's essentially what a resolution is anyways. So those are my suggestions when dealing with this. The last form that they created for this is this manufactured home addendum. And now this is an addendum to the contract to buy and sell real estate. What this is for is that, let's say you have vacant land, it's 20 acres, and there's a manufactured home that sits on the vacant land, and the title has not been purged. For those of you that have dealt in this world, you know that what purged means, but that what it essentially says is that the personal property has been affixed to the real property and it has become real property. If it's been affixed and the title's been purged, meaning there's no longer a certificate of title, then you can just use the regular form. That's a residential form. It's the same as you've ever done it before, or it's a vacant land form with a residential addendum. No problem. This form is used when there is a certificate of title still on a manufactured home on the lot. If there is a certificate of title, meaning it's still personal property, this addendum allows you to add it to a contract to buy and sell for vacant land, and it puts in all the things that are necessary in order to sell that manufactured home. And so this has about UCC searches, and it has about inspections, and it has about source of potable water and lead-based paint. It goes through all the things that you need to sell that personal property again. And like I said, those are the two things that the Division of Housing has said that the real estate brokers are exempt, that they don't need to register with the Department of Housing, is if you are negotiating the terms of a lease in a mobile home park, or if you are selling if you're selling a manufactured home and negotiating the terms of a lease in a mobile home park. That's the first three contracts we saw. Or if you're selling a manufactured home and the vacant land or the land that it sits on, that is exempt. So that's why those forms dovetail with that exception under the statute and under the Department of Housing. And that's why they built those forms for you guys, so that you could do those transactions because you do have an exemption. So I know that was probably confusing, and it looks like there's only 23 questions. So I guess we'll take some questions before I talk about my fun new one.
Okay, so there were a couple questions clarifying. These forms are required as of January 1st of 21, correct? And do we need to update current contracts with the new contracts as of January 1st?
I don't even know how to answer that question. And the reason I say that is because I don't know what you have currently. Contracts to buy and sell are not appropriate. They're not the right form. They don't work for these transactions. They could be considered, it could question competency. However, if you got a signed contract, I hate changing contracts. I don't. So I don't know how to answer that. I'm going to tell you, go back to your employing broker and ask how they want to handle it. Because I think it all depends on the circumstances around that transaction. If everybody's getting along swimmingly well, then January 1st, I would change over. If they're not getting along, then I probably leave well enough alone and hope it closes. If you've had a manufactured home contract put together by an attorney, or you're using something else that's appropriate for the transaction, then I absolutely would not change anything. What concerns me is that a lot of people are using the contract to buy and sell personal property, and that creates problems. But yes, they're available and required January 1st.
Can you use a regular listing agreement if it's not real property?
Yeah, you can. I don't see any reason you can't. In fact, I think you should, because there isn't anything that the division created for you guys to use that. The advantage about the listing contracts is that they're for services. They're not actually, it's a services contract to sell real estate is what it is. But if you put in the property portion of the listing contract, the fact that this is a manufactured home on a lot, I think that'll cover you. It's not ideal. I get it's not ideal. I don't know what the solution is, but we ran out of time. We couldn't get a whole suite of forms for every situation. But I would think that you're still fine using the listing contract as long as you're very clear about the fact that this is manufactured home sitting on a leased lot.
Somebody asked about a class on manufactured homes. I know Damian's got one. He's teaching a 3-hour CE class on December 15th. That'll be a live Zoom class. So that's an option. And I imagine you'll start to see more of those classes hit the market at some point. But
yeah, I imagine at some point somebody will be what people. I'm offering it because obviously I know the form, but I'm sure that others will be offering it. I mean, the reality is manufactured homes have become our affordable housing in a lot of respects. In fact, it's amazing to me the price that some sellers are getting for their manufactured home that sits on a leased lot. Normally, those trailers are not worth much used, but because they have a lot, and because that lot is, the owners of that park are willing to transfer that lease to the new buyers, those manufactured homes have some value right now.
is manufactured, mobile, and modular homes synonymous from a Colorado Real Estate Commission perspective? And does each have a HUD tag?
So the HUD tag this is about certificates of title, actually. So if they're, which is in the DOLA memo is a little confusing. If you've read it, you might have to blow your brains out after reading it, because I thought that lawyers wrote bad. Don't tell anybody from the Department of Housing I said that. But it talks about how tiny houses that are on a trailer don't count, but the way I see it is so that the federal government defined mobile homes up until 1983 were called mobile homes, and then they turned to manufactured homes. And it's anything that's on an axle with wheels and it has a certificate of title. And then once they remove the axle and they remove the certificate of title and the serial number, they can affix it to the property, and that's called purging the title. Once it's purged, it becomes part of the real estate, and then we don't have to deal with any of these forms. But until that certificate of title is purged, then that's the transactions we're talking about here. So it does not include ones that you're selling out of a parking lot. Those you need a dealer's license for. It does not include ones where you're the owner of the manufactured home park and you're selling ones in your park. Then you have to have a dealer's license as well. This is really for real estate brokers selling these manufactured homes that have not had their titles purged and still have a certificate of title. I hope that answers the question, because it gets a little muddy at times.
Are these contracts on CTME?
They will be January 1st when they're available. I'm sure they will be. They're real estate commission approved forms. So I'd say 99.9% chance of them showing up there. But I'm a lawyer, so I can't give you 100%.